And the floor is yours. Thank you.
5 points to reply to.
Yes.
The first one is the firearm issue. It is an important issue, although my learned friend tries to make light of it, because it's all regulated by statute. Firstly, your leadership wanted to know what the source of the evidence is. The first part is page 21 of the report by Ms. Thompson, at paragraph 50.4, where she says, it appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from the tactical security services, who provided security services at the celebration event. However, no individual was convicted of supplying or transferring the firearm to the accused. And this is the crucial part. And the rifle was shown in court was returned to tactical security services before judgment was delivered in this trial. That's the first part of the source. Then, if you then goes to the transcript of the evidence of Ms. Thompson at page 35 at line 8. She says, however, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to tactical security services before judgment was delivered in this trial. Now, why does this matter? It matters because the forfeiture of firearms that are used in the commission of offences regulated by the Criminal Procedure Act. My learned friend has already referred us to section 30 of the Criminal Procedure Act. But your leadership will discover that section 30 is actually inapplicable in the current circumstances, because it deals with disposal by police officials of articles after seizure. It doesn't deal with articles that are part and parcel of the criminal proceedings themselves. Similarly, section 31, which is another section that was relied upon by the refers to disposal of articles where no criminal proceedings are instituted, or where the article is not required for criminal proceedings. So we know in relation to the first requirement that criminal proceedings were instituted, and in relation to the second requirement, the firearm was required for criminal proceedings. So it also does not apply. What does apply are the two sections that were not referred to by my learned friend, which is section 34 of the Criminal Procedure Act. That section is headed Disposal of Articles After Commencement of Criminal Proceedings, which is where we are. The criminal proceedings have commenced. The article is a piece of the evidence that can be used to prove the offense. It says the judge or judicial officer presiding at criminal proceedings shall, at the conclusion of such proceedings, but subject to the provisions of this Act or any other law under which any matter shall or may be forfeited, make an order that any article referred to in section 33 be returned to the person from whom it was seized, if such person may lawfully possess such article. So it is up to your leadership to make an order that an item that was part and parcel of the commission of the offense, which was used in the criminal proceedings, may be returned. It is not up to the state. Why that is important is also section 35, which is another section that was not relied upon by the state. That deals with the forfeiture. So your leadership will know under section 34 you may order the item to be returned, but under section 35 you may order the item forfeited to the state as well. Because under section 35 subsection 1, it says a court which convicts an accused of any offense may, without notice to any person, declare any person, instrument, or other article by means whereof the offense in question was committed or which was used in the commission of an offense, or if such conviction is in respect of an offense referred to in Part 1 of Schedule 2, any vehicle, container, or any other article which was used for the purposes of or in connection with the commission of the offense in question, or for the conveyance or removal of the stolen property, and which was seized, and we know this firearm was seized under the provisions of this Act, forfeited to the state. So what happened here is that the prosecutors, on their own showing, agreed with one of the accused persons to take the firearm before judgment was given. That raises profound questions of the propriety of the conduct of the prosecutors. They themselves admit that they sent an email, although they put a different slant to that email. The slant they put is that they said, if you are acquitted, you may come and collect the firearm. Whereas the provision in Section 34 says the judge or the magistrate, whoever is presiding, may make that. It raises profound questions, my lady, with the greatest of respect. The first is, how does the accused know that he must come and collect the firearm? But it also raises another question, which is, how did the state take this matter as serious if they were already making arrangements prior to judgment upon the return of the firearm? They say that there were emails that were exchanged, but those emails have not been produced. And that is in the context where a witness has given evidence. It is correct, as my learned friend points out, that the witness says, my source of the evidence, you see that in paragraph 5.1 of the report, my source is Mr. Malema. But if they had this email chain, you would expect that on the day the witness gives evidence, they put it to her. But they don't. And then they try to get that evidence introduced in argument, which your ladyship can just dismiss without more. So we submit, therefore, your ladyship, that there is a potential irregularity which flows from the non-compliance with Section 34 of the Criminal Procedure Act and the non-compliance potentially with Section 35 of the Criminal Procedure Act. But we say it also raises really profound questions about how this knowledge occurred prior to the delivery of the judgment. We leave it there and take it no further, but we say it does raise deeper questions that require interrogation. But it does show that even on the state's showing, they did not regard the offense to be serious. Why do you return the instrument of the commission of the offense prior to the delivery of the judgment? Why? So that's in relation to question 1, which is the return of the firearm. We say it's relevant to sentencing because it shows that the state did not treat this as serious, but it's also relevant to a larger question about the propriety of the conduct of the state. The second question I want to address then is to look closely at why does the state say Mr. Malema should go to jail? This is clearer because the main heads of argument are actually quite confusing about why they say that he should go to jail. It's clarified in the supplementary heads because there they identify 4 reasons, and I want to address each and every one of them now. The first one is this idea of premeditation, that the offense in question was premeditated. But it seems that they actually misread the evidence because the planning that Mr. Malema talks about, if you look at the supplementary heads of argument, the leadership will find this at paragraph 7 of the state's heads of argument. In the italicized portion, which has inverted commas at the bottom of the page, where Mr. Malema is quoted as having said everything was perfect and calculated and designed to be the way it was done. He is not talking about planning the commission of an offense, he's talking about planning the celebration, the celebratory event, even on what they have quoted here. So that's why it's important never to read words out of context. What they have done is that they have planted words in their heads of argument, and then they have imputed a meaning that those words were never designed to achieve. And we say, in addition to the distortion of what the actual evidence was, the evidence was not planning the offense, the evidence was about planning the event, that actually cases of planning and premeditation of of a design. How are we going to rob a shop? How are we going to rob a bank? What they don't show is the spontaneity of a firearm being given to a person, one shot, which is on the evidence, and your ladyship, you'll see from our heads of argument. But the second conviction is about one bullet. It's one bullet, not the 22 bullets, one bullet. So ordinary cases of premeditation do not have that element, because what you find is that a group of criminals sit and they plot how to execute an offense. This is not where someone gets a firearm, they shoot, they retain the firearm, and that's the end of the story. So it's even inconsistent with a classic instance of premeditation. And bearing in mind, my lady, that the state says, if you look closely at what they say in paragraph 7, the most significant aggravating feature. In other words, they hinge their case on the premeditation. But if the basis of the premeditation is a misconstrual of the evidence, your ladyship can discard that without more. So that's item 2. So we say your ladyship can safely discard that because they've misconstrued the facts. And in any event, they overlook the fact that we're talking about one bullet. The second reason why they say Mr. Malema should go to prison is because they say it was 2 firearms. But we don't understand. They say 2 firearms, 22 live rounds, and 20,000 people within a community. We don't understand why they say that. If your ladyship goes to our heads of argument, we start off by summarizing what the actual findings were, not what the state wishes the findings were, but what the court said the findings were. And the important ones is 1.2, unlawful possession of ammunition in contravention with Section 90 of the Firearms Control Act, to wit. Now those words, to wit, usually mean in that. In other words, their point is to constrain the factual basis of the finding, not to expand it. A .223 Remington bullet, one bullet, without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export, or in transit license or other authorization. 1.3, unlawful discharge. But that's the unlawful discharge of the one bullet that he was in possession of, referred to in the second conviction. So we have the same problem here, my lady, with the greatest of respect, that the findings are distorted. It's a narrative building. Yes, and my learned friend also points me to even the first finding is unlawful possession of a firearm, not the firearms. A firearm, one bullet. So we've got a problem here that when you look at the second reason why they say Mr. Malema should go to prison, there is a disjuncture between what the state says and what the court found. And you can't do this. You can't send somebody to prison for reasons that the judge did not find him guilty of. So this is the problem now with item 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't only send him to prison, send him to prison for 15 years. So it's like a game that they are playing. It's a game to inflame the passions of the public. Then the next reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader and a role model. Now here, my lady, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we were here during the evidence of Ms. Thompson, when your ladyship commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of Section 9, everyone is equal before the law. So So in other words, my lady, what we have is that we've got the state that chops and changes its case depending on what it wants to achieve at a particular point in time. Today, they are trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentarian. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had a propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in Parliament? Why should he not lose his seat in the JSC? And the fact that, my ladies, the fourth part of it, is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There is only one punishment as far as that concerned, is custodial. So what we say, my ladies, is that you have a range of penal options that would reflect the society's disapproval of, I would say, public misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite. So we say that ultimately is a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt versus S, absence of remorse is not an aggravating factor. The state says that in paragraph 17 of their heads of argument. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty, the state says, infer from that he's not remorseful. It's absurd because even under Section 35 of the Constitution, he has a right to an appeal. And the right to an appeal is based on a view held by an accused, wrongly or what, that the magistrate is wrong. You cannot say, I am going to punish this accused because he articulated a view that I am wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong, and I'm going to appeal. The judges on appeal may say to him, Mr. Malema, it is you who's wrong, and not the judge. But in expressing a penalty, a judge cannot say, I'm going to punish you more because you've said it's absence of remorse just because you say, I do not agree. And I want to take this point further about the absence of remorse. They say, Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent. That's what they say in their heads of argument. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you know what happens? They violate Section 179 of the Constitution, which says that they must prosecute without fear, without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with the law. So we say that there is a deeper problem with this idea that because he said they were incompetent, therefore he must be punished, because it's not retributive, which is fine for sentencing, but it's vindictive, which is in conflict with the Constitution. So we say your leadership cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph 18, where in B they said, he described the proceedings as an abuse of the NPA resources and an incompetent prosecutor, and that AfriForum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is AfriForum that has been behind the prosecution of Mr. Malema.
On which ones? Supplementary or the first one? 18B.
So there they say, Mr. Malema complains of a political vendetta by AfriForum. That's the point I'm addressing. Leadership doesn't want me to refer to AfriForum, that's fine.
No. Sorry, Advocate Nkukaitobi. I'm just quickly reading what you are referring me to before saying that I don't want you to say it. Let me just read the paragraph quickly. Okay. Advocate Nkukaitobi, I've got that. I hear you. This is what the narrative of your client's evidence was during his evidence in chief and cross-examination, which the state is quoting here, according to my understanding. But you may proceed. I'm noting what you are saying.
Lady, it is the state that says that Mr. Malema lacks remorse because he has blamed AfriForum. I'm simply explaining.
And the Holy Spirit, including
I'm not dealing with the Holy Spirit, I'm dealing with AfriForum.
Please leave. I've spoken, so I was very clear that there'll be no choice. So I don't know how we are going to approach this. It's distracting to counsel for the accused. It's distracting to the state and to the court. And I do not need your approval of yes and no, because I'm independent. I don't mind yes or no at all. So do you leave or what? Because I'm not going to tolerate it. So there's a whoever wants to comment, please leave. Whoever is commenting now, please leave. And from now on, I will leave that in the hands of SAPS. Whoever comments or speaks, ask them to leave, please, because I'm concentrating on what counsel is saying to court. Sorry for that.
Let me just make one sentence on AfriForum, because I think that's what is increasing the temperature inside.
I'm listening.
Mr. Malema is entitled to regard AfriForum as a political adversary and to criticize it for an unfair prosecution because he believes that they are behind his prosecution. What you cannot do, you cannot take that political statement by Mr. Malema and take it to account in sentencing.
I hear you fully, yeah.
Thank you, ma'am. Then they are also complaining that he has complained of racism. Why is the state complaining that Mr. Malema is complaining of racism when he's a victim of racism? It makes no sense to me at all.
Okay, I'm not going to respond, but I'm listening, yes?
No, I'm not asking your leadership to respond. It's a rhetorical question. Is why would the NPA complain that Mr. Malema is saying this prosecution is part of a racist campaign against? Why would they have an issue with that? And why would your leadership be required to put that in your judgment in sentencing? Now, the last one is the Holy Spirit. Nothing else to be said about that. Yes. Then C is showing no insight to the danger of 20,000 people. But if you look at closely, my lady, it is precisely the same point as Roman figure 2. Nothing is added by putting it here. Then D, he has sought throughout to conflate the rule of law with political persecution, undermining public confidence in the administration of justice. Now, it's unclear what are the facts on which they rely here. Why do they accuse him of undermining public confidence in the administration of justice? What did he actually do? Because, my lady, people that undermine confidence in the administration of justice, you know what they do? They don't come to court at all. They shout at the court from outside, and then they are ultimately found guilty of contempt of court for not showing up. Mr. Malema has been exemplary throughout the trial. He has been truly exemplary. If he's told to come on the 9th to the 20th, he's here on the 9th to the 20th. Come at 8:30, he's here at 8:30. He has never once missed a beat. When he had to give evidence, obviously his personality came through, as you heard from the witness, who said he does have a combative style of speaking. But having a combative style of speaking should not be conflated with disrespect of the judicial process. So we would submit to your ladyship that you cannot take this factor into account. There's just no evidence that Mr. Malema ever acted in a manner that shows disrespect to the proper administration of justice. This is particularly so when the prosecutors are not confident enough to pinpoint the specific evidence on which they rely for saying he has undermined the administration of justice. And then, my lady, here's the point I was making in paragraph 19. Critically, the probation officer, Ms. Thompson, herself acknowledged that the accused continues to assert his innocence. So, this is the point, my lady. After conviction, the accused says, I'm innocent. Now the state says, take that into account against the accused. He will say he's innocent until the constitutional court says you are guilty, at which point he will then accept that perhaps I'm the only one who believes I'm innocent and everyone must think I'm guilty. But the mere fact that at this stage he is asserting his innocence is not a factor that counts against him. But if you did that, you then violate Section 35 of the Constitution that gives you the right to appeal. The last point, my lady, is to correct some legal misconceptions. Your ladyship has been given this case, Janssen versus the state, by Fansei DJP. My lady, this case is unhelpful to you. This case is about someone with previous convictions. It is a case where minimum sentencing legislation applies. And it is a case, if you look at paragraph 2 of the judgment, where it says the appellant produced the firearm, Robbenheimer ran away and he heard the sounds of gunshots. The appellant was known to him as being a member of a gang called the Fat Cats. It's a case of gangsters. It's not a case of a politician in a temporary lapse shoots a firearm to the sky. This is a case of proper gangsters. There is absolutely no basis why the prosecutor says you should read this judgment. It will help you, because it will not help you. Then, my lady, you have a collection of cases. And again, this is another misconception. We've cited, and I will ask your ladyship when you retire to have regard to these judgments. In paragraph 31 of our heads of argument, we've done precisely what the state says we didn't do, which is to separate cases of possession from cases of discharge, and to look at the patterns of sentencing for possession versus the patterns of sentencing for discharge. What we find at paragraph 31, and this is all set out very usefully in the judgment of Cluster J, S versus Matikane, where he refers to, I think at that point, all sentences that he was aware of on possession. So, you see, S versus Malema, the sentence that it was an automatic firearm, not semi-automatic, automatic. The sentence was, there was a direct imprisonment. On appeal, it was altered to 2,000 hours of periodic imprisonment. S versus Zondi, where there was a conviction and a direct imprisonment, but converted to a fine of 2,000 rands or 18 months imprisonment. And then the last one that would be relevant for our purposes is S versus Limo, which is the last of those cases. Initially 18 months, and then ultimately converted to 6 months, fully suspended. Those are possession cases, possession. And then we then deal with discharge cases, which we start dealing with at paragraph 35. S versus Fayoun, S versus Pistorius, Munsami and Anaga, and the Bada versus S, paragraph 41. Yes, 4 judgments. What the pattern appears to be, my lady, is that almost invariably, in discharge cases where there's no harm, no direct imprisonment is ever ordered. Pure discharge. No direct imprisonment is ever ordered. All of the cases we found. Discharge the firearm in the sky. I mean, Julius' case was actually a paradigmic one because it's actually in an enclosed room. It's not here in the court. The place is full of people, and then Oscar shoots the firearm. It's not his firearm, someone else shoots it to the roof. And then they say 3 years fully suspended. Don't go to prison. So the pattern on discharges where no harm is an issue is non-custodial as a default position. For possession, the pattern is mixed. I accept what my learned friend says, that there are cases you will find of 7 years. But virtually every case we've looked at that they have cited always involves that this one we've looked at gangsters or some sort of other offense that is the possession is part and parcel thereof. Not one case involves an instance which is what we describe as a fleeting possession. Somebody comes in, take this firearm, shoot it inside the car, bring it back to me. Never found a case like that. So it is not correct for my learned friends to ultimately come to the conclusion that the pattern of sentencing in possession cases reflects custodial sentences of between 7 and 15 years. That's just not part and parcel of the law. So, my lady, what you have, you really have a wide canvas. A wide canvas that starts from fully suspended, mixed suspended plus fine, or fines. Then it stretches all the way to 15 years. That's the true state of the law. And we have shown in this case the unique facts that were pleaded by Ms. Thompson. My learned friend can complain about Ms. Thompson's bias, etc., but the fact of the matter is there's only one witness on sentencing, one witness. The state could have controverted that by bringing their own witness. They never did so. So, my lady, we come back then to the beginning. We ask for a non-custodial sentence. But the nature of that non-custodial sentence is in your ladyship discussion. What we simply say is that it will be contrary to the law. Not because we like Mr. Malema or anything. It will be contrary to the law to send him to prison. Thank you very much.
Thank you, Advocate Nkokatobi. Thank you. There's no provision for you to reply, Advocate Caesar. This is it. The defense, am I going to indulge him? It's not procedure. He wants to rise, so you may outvote him.
It's supplementary to the argument, and even after his arguments, he has an extra point.
Okay, the extra point I disregard, but with the rest, we stick to procedure. Is it a new point?
There's no need to address anything.
What you want is not raise the point, but on what is the basis of you wanting to do so, that I can listen to, and then I can tell you yes or no.
No, you was just going to advise council to read section 30 and 24.
No, that is a no. All right. Thank you, Advocate Caesar. All right. So that is us for the day.
But then, since no one is speaking to your leadership when you're asking that, is it? The one thing we agree with the state on is that we need to get finished with this.
Yes.
If your leadership is ready with a judgment this afternoon, we would appreciate it.
Advocate Nkukai Tobi, let me be very clear and maybe indulge not in a because I'm not ready. The aspect of sentence today is still to be decided. Let me explain so that everyone, and I'm sure I do not have to explain, you are all senior officials and very much aware of what I'm about to say. What you read on paper materializes when it's said loud in court. The impact, the tone is not reflected on paper. It's heard and experienced when you are in court. So the actual sentence, yes, must be determined. Having done the groundwork and the summaries, that has all been done. But to say proceed when I've just heard a whole lot of additional information, I have to structure and...
I have absolutely no problem. The leadership is adjourning us to a date to be advised.
No, we've got 2 days and I intend to do our utmost to reach our end goal. I just don't want to say and commit after I've explained why, and you all know when you read and when someone says it's a totally different impact when you hear and when you read in your office. It's then you go back, as you say, you retire, not yet though, and you combine the two. So that is what I intend doing this afternoon. So we can, sorry, I see I'm keeping you on your feet, but you are free to take a seat. I can go to the extent of, just so that we don't waste time at 9 a.m., to place the counts and the penalty clauses and the minimum, the formalities on record, because that's not something I have to prepare. It's a fact before all of us, but I need to place it on record. I can do that. Or we can say 9 a.m., but I'm not going to go beyond that. So,
Lady, we are just in your hands.
I think it's inconvenient for everyone for me to come back. I will ask you, and maybe you can, Advocate Otis, Caesar, your client. I'm thinking of all the media stations and subs to return for me to read out a formality which is known to all, or come back at 9 a.m. But I intend, as I say, not to go beyond and for us to reach our goal as planned.
At 9 a.m. tomorrow.
Then your word is my command. Agree, Advocate Caesar? All defense? All right. Charge sheet. Mr. Malema, just a minute, please, gentlemen. The court is not adjourned yet. We are still busy. For the reasons I've mentioned then, and for us to, or for the court to proceed or commence with sentence, and hoping that we will reach the finality of this matter tomorrow for anything that may follow. Tomorrow, I would assume it is the same venue, but I'm also directed by the management. I assume it's the same, 8:30, for us to start at 9 a.m. I'm sure the same venue, which is High Court venue. Okay. Thank you. Court will adjourn.